Welcome to the deep dive. Our mission today, well, it's to cut through some really confusing parts of criminal homicide. We're talking about murder definitions that don't actually require the person to have intended to kill. We're moving past the clear-cut, purposeful killing,
Mm.
and diving into situations where someone dies because of really dangerous actions, or maybe just because someone intended serious harm, but, well, not death.
That's exactly right. We're navigating these tricky areas of malice aforethought where you don't have that smoking gun, that explicit plan. We've got two main categories on the docket. First up is the old common law idea, intent to do serious bodily injury murder. Then we'll tackle the one that often feels more subjective, depraved heart murder, sometimes called extreme indifference murder, and we'll use some key cases, break them down to build a framework, a tool you can use right away.
Okay, let's unpack that first one. Intent to do serious bodily injury murder. What's the basic rule? And how serious does serious bodily injury have to be? Is it like way worse than a regular assault?
So the general rule is pretty straightforward at common law. If you meant to inflict really serious harm, grievous bodily injury, they called it, but your actions actually ended up causing death, well, you could be found guilty of murder, assuming, of course, there's no valid excuse or justification.
But hang on, why murder? If they didn't intend death, why isn't it manslaughter? That seems like the more intuitive fit.
That's a great question. The law basically sees the intent to cause injury that's so severe it comes close to death, even if it doesn't equal it, as having sufficient malice. It's considered just as dangerous and morally blameworthy as the kind of extreme recklessness we see in depraved heart cases. And serious bodily injury, it's definitely more than just, a minor injury. Think great bodily harm, serious disfigurement, long-term damage, that sort of thing. If you only intended a simple battery like a punch and death unexpectedly resulted, yeah, that's almost certainly looking like manslaughter.
Okay. Now, I know some modern laws, like the Model Penal Code, actually got rid of this as its own separate thing, right? They rolled it into recklessness. But in places where it is still recognized, how does the prosecution prove someone intended serious bodily injury? Especially if there wasn't a weapon, like a gun or knife involved.
Right. Intent is tricky. It's almost always inferred from the surrounding circumstances. If someone uses, say, a deadly weapon, the inference is pretty easy. But, and this is crucial, the intent can sometimes be inferred even if the only weapon used was the defendant's own body, their hands, their feet. That inference becomes much stronger when the victim is particularly vulnerable, maybe an infant or someone very elderly or frail. That vulnerability makes the physical force inherently more dangerous.
Let's test that idea right now with a classic case that deals exactly with this non-weapon intent, Commonwealth v. Marshall. Let's analyze Marshall. First, what are the legally dispositive facts?
Okay, Marshall. The defendant choked the victim. The key finding was that he intended to cause great bodily harm, but the evidence suggested he did not specifically intend to kill her. But despite lacking that intent to kill, the victim died as a result of the choking.
And what was the core legal issue the court had to decide?
The main question was straightforward. Could a murder conviction stand based only on the intent to inflict great bodily harm when there wasn't that explicit intent to cause death?
What rule did the court apply to resolve that?
The court basically reaffirmed the traditional common law rule. It said, yes, the intent to do great bodily harm is enough malice for murder. And importantly, they added that this intent could be inferred from using force, like hands or feet, especially when used against someone vulnerable.
What was the court's analysis? How did they justify equating that intent with murder?
Their reasoning really zeroed in on the sheer danger of the defendant's actions. They argued that intentionally using violence calculated to cause serious bodily injury, even without a conventional weapon, is just as fundamentally dangerous to human life as the kind of conduct needed for, say, depraved heart murder. That inherent dangerousness justified the murder charge.
And the final conclusion?
The holding was clear. The defendant was indeed guilty of murder under this intent to injure standard.
Okay, that clarifies the intent to injure pathway. Now let's switch gears to depraved heart murder.
Yeah.
This one feels fuzzier, maybe? It's based on risk, not intent. What's the black letter rule here? And how do we tell the difference between the degree of risk needed for this versus the lower standard for involuntary manslaughter?
You're right, it can feel fuzzier. Depraved heart murder or extreme indifference murder requires really, really reckless conduct. Conduct that creates a very high degree of unjustifiable risk of death or serious bodily injury. This is where, like you said, drawing the line gets tough. The risk has to be more than just an unreasonable risk, that's your basic negligence. And it also has to be more than a high degree of risk. That level usually lands you in manslaughter territory. This needs something extra.
So not just reckless, but like
Hmm.
super reckless. How do we even picture that difference between high risk for manslaughter and very high risk for murder? Is there a good way to think about it?
Yeah. Super reckless isn't a bad way to put it. Think about it like this. Driving, say, 90 miles an hour on an empty, winding country road at night. That's definitely risky, probably a high degree of risk. If you crash and kill someone, maybe that's manslaughter. But now imagine driving 90 miles an hour blindfolded through a packed school zone during dismissal. Same speed, totally different context, right? That extra quality, the complete, utter disregard for human life, the context is the extreme indifference the model penal code talks about. The conduct has to scream that you just flat out didn't care if someone lived or died.
Ah, okay. So it's not just the odds, the math, the risk. It's the whole picture, the moral context. And you mentioned the social utility of what the person was doing.
Absolutely crucial. The risk must be unjustifiable. Think about a surgeon performing a really complex, risky operation to save a patient. High risk of death? Maybe. But huge social utility, right? Compare that to someone speeding through a crowded downtown street purely for the thrill of it. Zero social utility. In that case, even a statistically lower risk can look much more depraved because there was just no good reason for taking any risk like that.
Let's apply exactly that idea, utility trumping pure statistics, to Banks v. State. Seems like a perfect example. Let's analyze Banks. First, what are the legally dispositive facts?
Right, Banks. The defendant fired 2 bullets into the back end, the caboose of a passing train. Tragically, he killed a brakeman who was inside. Now, the interesting part is that sources suggest the actual mathematical chance of hitting and killing someone might have been pretty low, maybe only 5%, considering the size of the caboose versus a person's vital areas.
And what was the core legal issue in Banks?
The key question was, could that relatively low statistical probability of death, that 5%, still count as the very high degree of unjustifiable risk required for this type of murder?
Wait a second. Only a 5% chance. How on earth does that get labeled a very high degree of risk? That sounds counterintuitive, doesn't it? Almost like the definition is stretched.
That's exactly the tension the court had to grapple with. The rule they ended up applying wasn't about the raw percentage. Instead, they said the required risk level is judged by what the defendant should have realized given all the circumstances. And critically, that risk has to be weighed against the social utility or lack thereof.
So what was the court's analysis then? How did they bridge that gap between 5% and very high risk?
The analysis really hammered on the complete absence of any social utility. There is simply no justifiable reason, none whatsoever, to shoot bullets into an occupied train car. Period. Because the act was so utterly unjustifiable, so pointless, and showed such a profound indifference to whether people were inside or not, the court basically decided that even that 5% risk was enough to demonstrate the necessary extreme indifference to the value of human life. The lack of justification magnified the perceived risk.
And the conclusion from the court?
The murder conviction was upheld. That low probability didn't save him because the act itself was considered so depraved.
Okay, to really make this extreme indifference concept stick, let's talk examples. Give us some of those classic, maybe even visceral fact patterns that courts consistently say do qualify as depraved heart murder. What kind of conduct just screams total disregard for life?
Right, the memorable examples help. The conduct really has to show that the person understood they were gambling with someone's life and just did it anyway. Classic ones you see are playing Russian roulette with someone else's head, firing a bullet into a room you know is occupied, even if you don't aim at anyone specific, or piloting a speedboat wildly through a group of swimmers, or the tragic cases of shaking an infant so violently and for so long that the baby suffocates and dies. The common thread is that conscious disregard, that awareness of potentially lethal danger, combined with choosing to proceed.
That awareness part brings up a huge debate, right?
Yeah.
The mens rea. Does the defendant actually have to know subjectively that they're creating this massive risk? Or is it enough if just a regular reasonable person would have known the risk, even if the defendant claims they were oblivious or maybe just didn't think it through?
Exactly. This is the historical split. You had the Stephen view pushing for subjective awareness. Did this defendant actually realize the risk? Versus the Holmes view, the objective standard, would a reasonable person have realized it? Now, most modern American laws, and definitely the Model Penal Code, lean towards requiring subjective awareness of the risk. They call it recklessness. Plus, you still need that extra extreme indifference quality judged objectively. The argument for subjectivity is pretty strong, especially for murder. The idea is, for such a serious crime with such heavy penalties, the person really needs to be morally blameworthy. Someone who is just, I don't know, dangerously clueless might be seen as less culpable than someone who knew the risk and consciously ignored it.
Okay, subjective awareness is generally key. But you mentioned an exception, a big one that comes up all the time: voluntary intoxication. What happens if the defendant didn't realize the risk because they were drunk? Does that get them off the hook for murder?
Ah, the intoxication issue. This is where the law makes a specific exception, kind of a policy carve-out. The vast majority of courts, and the Model Penal Code is very clear on this, say that voluntary intoxication is generally irrelevant. It does not prevent a finding of a depraved heart. Why? Well, the thinking is often that someone who gets voluntarily drunk and then creates a massive risk is arguably morally worse, or at least just as dangerous, as a sober person who consciously ignores the risk. They're held responsible for getting into that impaired state in the first place. It closes a potential loophole.
Let's look at a case that actually went the other way, adopting that stricter, purely objective standard. Regina v. Ward. Let's analyze Ward. First, what are the legally dispositive facts?
Okay, Regina v. Ward. Similar facts to one of the hypotheticals: the defendant shook an infant, which tragically led to the baby's suffocation and death. The critical point here was the trial judge's instructions to the jury. They were told to apply an entirely objective standard, basically. Would a reasonable person have known this was dangerous?
And what was the core legal issue on appeal?
The issue is whether it was proper to convict the defendant of murder based on that objective standard. Could he be guilty if a reasonable person would have realized death or serious injury was likely, even if the defendant himself claimed he didn't appreciate the danger? It was a direct test of the objective Holmes view.
What rule did the appellate court apply?
The English court explicitly approved the trial judge's instruction. They endorsed the objective standard for this type of murder in their jurisdiction. They essentially said, yes, if a reasonable man would have foreseen the extreme risk, that's enough for a murder conviction, regardless of the defendant's subjective state of mind.
What was the court's analysis? How did they justify using that objective standard?
Their reasoning focused on objective blameworthiness and the danger the conduct posed to society. They emphasized what should have been known rather than what was known by this particular defendant. It's a stark contrast to how subjective jurisdictions might analyze it. Think about a case like Commonwealth v. McLaughlin there. The defendant stopping and trying to help the victim after a fatal accident was seen as evidence against having a wicked disposition and hardness of heart, suggesting subjective state matters. Ward went the other way.
And the final conclusion in Ward.
The murder conviction was upheld. It firmly established the objective standard for depraved heart murder in that particular court's view.
Okay, we've dug into two really complex ways malice can exist without intent to kill. Intent to do serious bodily injury, focused on intent, and depraved heart murder, focused on extreme risk. Let's pull it all together. For you listening, maybe facing an exam or just trying to understand this, how can you synthesize these rules into a practical diagnostic framework when you see a non-intent to kill homicide fact pattern?
Right, let's make this actionable. Here's a step-by-step checklist you can use to spot these issues. 1. Check for intent to injure first. Did the defendant actually intend to cause serious bodily injury? Look for clues. Deadly weapons are obvious, but also think about vulnerability, like in Marshall. Choking an infant, for instance. If the answer is yes, and if your jurisdiction still recognizes this category separately, then you might have IHSBI murder right there. If the answer is no, or your jurisdiction folds this into recklessness, move to step 2. 2. Gauge the degree of risk for depraved heart. Did the defendant's actions create a very high degree of risk of death or serious bodily injury? And always ask, is this risk level significantly more dangerous than the high degree of risk that would just be manslaughter? You're looking for something qualitatively worse, profoundly reckless. 3. Evaluate social utility. Was taking this risk completely unjustifiable? Weigh the danger created against any possible social value. Remember, bank zero utility makes even a lower statistical risk look much more depraved. High utility, like emergency surgery, might justify even significant risk. 4. Check for subjective awareness. Generally, under modern views, like the MPC, did the defendant actually know they were creating this very high risk? Were they subjectively reckless? This is usually required. 5. Apply the intoxication exception. Now, the crucial exception. If the reason the defendant didn't realize the risk was because they were voluntarily intoxicated, remember the special rule, that unawareness generally doesn't matter. Voluntary intoxication typically won't negate a depraved heart finding. 6. Look for extreme indifference. This is the final layer, often viewed objectively. Did the conduct, taken as a whole, manifest that extreme indifference to the value of human life? It's that extra something, that moral failing that pushes extreme recklessness over the line into murder.
That framework really helps map out that blurry line between manslaughter and these forms of murder, where the killer didn't actually specifically intend death.
It really does. And what's always so interesting and challenging is seeing how judges try to explain that difference, high risk versus very high risk, to a jury. It often boils down to a kind of gut level assessment of the defendant's moral blameworthiness, which is why those visceral examples we talked about, Russian roulette, driving blindfolded, become so important in helping juries feel where that legal line should be drawn.
So, the big takeaway for you listening, malice aforethought isn't always about a premeditated plot or pulling a trigger with intent to kill. Sometimes, just consciously disregarding a risk that is so massive, so profound, that only someone with an extremely indifferent heart would ignore it sometimes, that's enough to qualify for murder.
And maybe a final thought to leave you with. If we think about the goals of criminal law, maybe deterrence is a big one. Does it make sense from a deterrence perspective to potentially treat the voluntarily drunk person who ignores an extreme risk more harshly than the sober but, say, completely absent-minded person who fails to perceive the exact same risk? The law draws that line pretty sharply for intoxication, often holding the drunk person fully accountable for murder, while the sober but unaware person might only face manslaughter. It really makes you question whether moral culpability or the sheer danger posed to society should be the ultimate measuring stick for murder.
Yeah.
Something to chew on. Easy answers.